Okay, I think we're starting to get everyone settled here, so we'll get going. I am Kevin Love. I'm a lawyer with the Community Legal Assistance Society. So we're in particular in the community law program. So we're based here in Vancouver, but it's wonderful to see everybody, particularly all the faces from out of town that I haven't gotten to see, or Sonia, even the faces in town I haven't gotten to see in a long time. So it's excellent to get to see everyone. I'll start by checking that the online folks can hear me, if there are any. I don't know if there's anyone joining online or, okay. They can hear me? Great. Okay, so we're a pretty small group here. So my vision for this, like originally was, for the last 3 years, all we've been talking about are changes, random programs that get created, changes to EI, like everything just going and changing by the minute. And now we're in a place where all of that is gone and we're back to the old system. And even for experienced advocates, I was thinking, we haven't actually dealt with the old system or the pre-pandemic rules for a long time. So it might be good to do a refresher. Now that said, we only have an hour. Going through the EI system in detail, start to finish in 1 hour will be very dense and very boring. So because we're a small enough group, I've got slides on everything, but I will just talk about whatever you want me to talk about. So what I was going to do here is just see if people in the room have particular areas or aspects of the system or issues they're seeing coming up that they'd like to focus in on. And then what I can do is I'll just skip slides, I'll skip ahead, I'll go and just make sure that we get those aspects covered. And if there isn't anything from the floor, well, then I'll just pick and choose as we go here. So I'll open it up. Does anybody have anything that they're confused about in the system with employment insurance or even the old benefits or anything that they really want some more information on or explanation of? Yep. Yeah. Okay, we can cover that. I think I've got some slides somewhere in here that will cover a little bit of that off, so I can talk about that for sure. And yeah. Right. And just for the benefit of the people online, I'll say the two things we got were the transfer from some of the other federal benefit pandemic programs to employment insurance, some problems there, if I had that right. And then the interaction of EI with other benefits, for example, provincial disability assistance. On the second one, I will give you a teaser, but I will also plug another session coming up tomorrow where Allison Ward and I will be doing an entire session on benefit interactions. What gets deducted from what? What's going to get you disqualified from what? And by that, I mean, Allison will be giving the session and I will be there because she knows far more about this stuff than I do. So I am just a tag along. Okay, great. And if things come up as we go along, feel free to stop me and we can dive a little deeper. There's one issue just to set the stage that I want to go a bit into because it's coming up a bit more, which is availability. And availability, as I'll come to, is this requirement that when you're on EI, you've got to be looking for work and you've got to be trying to get back to the workforce. And with the interaction, coming back to the interaction with disability assistance, PWD, with the earnings exemptions being annualized and higher, there's a lot more people qualifying for EI using part-time work. And that's all fine. There's no problem with that. But then there's this flip question of, okay, I qualified for EI with part-time work, but what does that mean for my job search going forward? What do I actually have to be available for going forward? And it's been confused. We've had a lot of cases on it. So I do want to drill down a little bit on that as well. So we'll try to cover those topics. So if you see me skipping slides, it's just because we've got an hour and you don't need to hear everything. And if I move quickly, it's just because, again, it's sort of background stuff that we don't need to dwell on, but just throw your hand up and tell me to stop if I've got it wrong. So, okay, so where have we been? In a pandemic is the answer. And in response to that, The government was rolling out programs pretty hastily. We had first the CERB, the Canada Emergency Response Benefit, from April 20 to September 20. And I think I won't go into it, but as most of you know, the EI system basically broke like a child's toy in the spring of 2020 when the pandemic hit. We knew the problems, and then they all just came to light. 40% of workers, 40% of unemployed workers can actually access EI, which is ridiculous, right? Back in the 90s, that number was 80. So we're down to about 40%. So it wasn't there for people. So they had to roll out these other benefit programs to cover that. Yep. Good question. So the question was, what has changed so much that has dropped the number from 80 to about 40? I think it's a bunch of different factors. Number one, the disqualifications are far more intense than they were. So disqualifications, which I'll come to, these are doing bad things to get kicked off EI, like quitting your job, getting fired for misconduct. That used to be a time limited penalty. Now it's a total you lose everything penalty. That's been fairly harsh. I think the I also think there's been changes in the labor force, just in terms of how people work and how many people are actually covered by employment, like traditional employment, where I'm a worker, you're my boss, doesn't describe a lot of what people do anymore. And so one of the challenges building the system going forward is going to be, okay, well, how do we cover those workers? There was also until the 90s federal funding for the program. So it used to be a tripartite funding model. We had workers, like you get a paycheck and you see the deduction for EI, right? Well, and your employer's paying money too. And the commission or the government used to kick in some money too. So it used to be tripartite. They backed out of the room in the 90s. So, I don't really know. It's a constellation of factors, I think. But the end result is we all woke up in the spring of 2020 with a lot of people being unemployed and a system that just didn't catch anyone. So what does the government do? To their credit, they roll out a bunch of programs. And, to the extent there are problems with them, we do have to remember they were writing these on Zoom calls, like really quickly. So it was hard. So they roll out CERB. That was the first one. The second purpose of CERB was that they actually couldn't process the EI applications fast enough. Everybody was unemployed all of a sudden, so they couldn't process them, so they got to push them forward. So the idea was CERB now, we'll figure it out later. In September of 2020, they catch their breath, and we have two things happen. They expand access to EI, but they also create these recovery benefits, which is like a parallel scheme for people who are out of work but not covered by the EI system. That goes on for about a year. And then last year, we still have this expanded or enhanced or easier, nicer, kinder, gentler EI system, but there's no parallel benefit scheme for self-employed people. And now we fast forward to where we are now, and it's pretty simple. We're back to the pre-pandemic EI rules. So we're back to the broken system that failed before. Yep, Sonia?
Or somewhere along the way, mention how CERB-related debt impacts on eligibility for EI. If they have a debt to EI because of CERB, how does that affect? Because we're starting to get an onslaught of those, right? Like the CERB recipients who weren't eligible and are now being asked to repay.
Right. I will definitely try to cover that with the few answers I have. So based on all this, I'm going to be skipping a lot of slides, and I'm actually going to pull out my phone so I can keep track of the time so I don't miss all this stuff. Because we're 15 minutes in. I'm on slide 1. Okay. So main thing about EI, all right, is it doesn't cover all workers. It covers workers in insurable employment. I'm not going to go into the weeds on what insurable employment means, but if you're an independent contractor, you're not covered by EI in most cases. There are some, but in most cases, right? There is a scheme for self-employed people. It is not terribly popular. where you can opt into certain benefits. The uptake is not great. Pretty much the only people who want to do it are people who know they are starting a family and are going to have big maternity or parental claims. That's really the only people who it's financially viable for. So it's not terribly popular. So self-employed people are largely out of the system now. There is a separate scheme for self-employed fishers. I'm glad there's no one from Prince Rupert that I can see, so I don't have to take questions on it because I have no idea really how it works. But it's based on not working hours. Oh no, no! It was. We've got some people from Hyde in the room, so I'm in trouble. All right, okay, good. But the system's based on catch, right? And the money you earn, you actually qualify with your earnings as opposed to everyone else qualifying with their hours. So it's a parallel scheme so that self-employed fishers actually have some access to the system. And there's sort of 2 seasons, summer and winter, and it's broken down. But I'm going to quickly turn slides before anyone asks me any questions. Yeah. And the system, just by way of overview, provides a number of different benefits. Regular benefits are what most of you know. That's the benefits for people who are out of work through no fault of their own. But the system over time has also been expanded to capture situations where people aren't losing their job, they just need time off work, right? And we'll go through some of those. Some of them will be familiar. Pregnancy benefits, parental benefits, sickness benefits, and then there's a suite of sort of care benefits where you're providing care. These aren't situations where you've lost your job. You're just taking time off work with the expectation often that you'll come back. The system does also fund training benefits to help get people back to work. Those are really nebulous. Basically, the system dumps a bunch of money down to the provinces, and the provinces roll out a bunch of programs. But because there aren't really reviews and appeals, you may not see that much of it. But just to be aware, the system does provide some assistance to help people get back to work. And just to set the stage for understanding the system, you really have to break EI down into 2 concepts that are same, but different. The first concept is qualifying. That's the front door. Do I even get through the front door? Do I have enough hours? Am I covered by the system? Do I have an interruption of earnings? Like, do I actually have the sort of the break from employment that I need to get covered? And have I done something to get me kicked off the system, disqualified? Those are front door problems. They are all or nothing. You are in or you are out. Like, there's no way to really fix it absent going back to work and getting requalifying. Then there are what are called entitlement issues. This is what you need to do once you're in the front door to keep getting benefits, right? So you can get in the front door, but if you're not out looking for a job, you're not doing a job search, you're not going to get benefits. So the difference between entitlement and qualifying is entitlement can be fixed, right? So if you're not available for work 1 week, you can start looking for a job and fix that problem. You don't get benefits for week A. You can get benefits for week B once you fix the problem. Like, a question I always love to ask is, can you get EI if you've, or can you stay on EI if you're taking a trip to Hawaii? The answer is you're not kicked off the system. You just can't get benefits for those weeks. You come back from Hawaii and are suddenly available for work and looking for a job, you can fix that problem. So it's not a permanent problem. Qualifying for regular benefits. I'm going to move fairly quickly through this. I apologize just for background. So the trigger is for regular benefits, 7 days, no work, no pay. So this means like you're off sick with a cold for 2 days. That's not an interruption of earnings. That doesn't trigger EI. That's why those sick days are so important, right? Because there is no EI coverage for those short-term illnesses, as one example. And one thing I will always flag, and I try to flag things in case you start to tune me out. Severance pay does not delay the interruption of earnings. Why is that important? Someone gets laid off, they get severance or pay in lieu, they still have to apply right away. It will impact when they get their first check, but just to be annoying, they are going to make that worker apply right away. So keep that in mind. A lot of claims go south because someone gets a severance package, waits 2-3 months, goes to apply for EI and they're late, and that impacts their ability to qualify. There's a lot of text on this slide. Just here's all you need to take from this. Generally, you qualify for EI with hours worked. You look back usually 1 year. Usually it's 52 weeks, okay? And you look back, generally, if you apply within 4 weeks, you're gonna look back from the day the person's laid off. But if they're more than 4 weeks applying for EI, then you're gonna look back from the date of the application. And because people will have been unemployed, that's gonna hurt their chances of qualifying. So the takeaway here is usually it's the last week, apply right away. That's pretty much what you need to know for that. Antidates, this base, yep.
Hello. Okay. If a person is under one EI benefit, say parental leave, and then they come back to work, say for a very short duration of time, you know, a week or 2 weeks, and then they are unemployed for, like, they're laid off, does the parental leave period disqualify them from other EI benefits?
No, but can you hold that question for about 3 more slides?
Yes.
Yes, okay. And if in 3 more slides I haven't answered it, you can demand the mic back. I think I need 3 more slides to answer that. And then, so I won't forget. I'll try not to forget. So yeah, antedates means basically I applied late, but I had a good reason. So consider my application to be made earlier than it was. That's all it means. So if you get workers who come in 6 months later, they didn't apply for EI, they've got a big, in that 52-week period, they got a 6-month chunk of unemployment and they don't have enough hours, you might be fighting for a back date to say, okay, the person actually filed 6 months after they were laid off, but they had a good reason. So I want you to treat that application as though it was filed on the day they were laid off, which is going to catch more hours. Okay. One of the beautiful things about the temporary EI measures was you just needed 420 hours to qualify. All benefits, everything, everywhere. There's none of this trying to explain how many hours you need. Unfortunately, that's gone. So now we're back to the old floating number of hours, and it's all tied to the unemployment rate in your region. That means someone in Victoria doesn't have the same number of hours they need as someone in Vancouver, as someone in Fort Nelson, as someone in Kelowna. It varies depending on the region and the regional rate of unemployment, and it can change. But it's going to be between 420 and 700. And aside from Googling, there's really nothing you can do to know.
Kevin,
Yep,
there's
sorry,
a question, yeah, online. What would qualify as a good reason?
Antedate? I mean, it runs the spectrum. There are thousands of cases on this. I mean, obviously, if someone's in a coma in hospital, that's a good reason. But sometimes people are just short of that. They could be very ill. There's a bunch of cases on bad advice, you know, mix up with filing things. And the one thing about this system that's been around for 90 years is you can go through the, you know, 100,000 cases that we're up to now. And for any given reason, you can find some that say yes and some that say no. So that's why some advocacy from you folks fighting on these issues is really helpful. But generally just ignorance of your rights generally is not a good reason. But if you did what, basically they asked, did you do what a reasonable person would have done? You know, so that's kind of what you, that's kind of the mindset I would get into, but there's no end to the list in terms of what could be cause for backdating or antedating. Okay, so disqualifications, and I said 4 slides I would answer the question. I'm now realizing I may need a slight extension of about 6 slides before I can answer that question, but I will get to it. Fine, good. Okay, so disqualifications. Everything's going well. You've got your hours, you know, you qualify. There are things you can do to disqualify yourself. And there are 2 biggies. One is losing your job due to your own misconduct. That is not the same as just cause. EI just asks whether you lost your job due to your own misconduct. Just cause looks at the employer's response. If an employer responds too harshly, worker can do something bad, but worker may not have had just cause and may still owe them notice, may still owe them severance, may still owe them that. They don't look at the employer's response in EI. The question, it's a little harsher. The question is only, did you lose your job due to your own misconduct? The second is, did you voluntarily quit without just cause? If you quit, generally, you're not going to get benefits, but the system recognizes that some workers have a just cause for quitting. What are some examples? The workplace is unsafe. They've experienced harassment or antagonism from the employer. They have to accompany a spouse to a new city. There's a whole list set out in the act. But the key thing, again, if you take anything away from this, is the test is not, did I have a good reason? The test is, did I have no reasonable alternative? So in other words, quitting has to be the last option, not just a good option. If so, as an example, worker thinks workplace is unsafe and decides I'm not coming to work. That makes sense to me. I get it. Like that makes good sense. And I think it makes good sense to everyone in the room. But what EI is going to ask is, okay, did you raise it with a supervisor? Did you raise it with someone above them? Did you contact WorkSafe? And what steps did you take to resolve the problem short of quitting? So quitting can't just be a good choice. It has to be the only reasonable alternative. And look at this. I put a scenario in after saying I would answer the question in 4 slides. So now I have to ask for another indulgence, which is to break up my voice, do a scenario, and then come back and do the slides that answer the question. So I hope I can get yet another extension to question answering here. So just to break it up a bit, I've thrown out a little scenario. What we'll do is just in our tables, take a couple of seconds just to talk about it. Like, in fact, rather than jumping right to whether you think Juan would be disqualified, think about, you probably are going to need more information. What kinds of things would you want to ask Juan about what happened? So I'll stop talking for a couple of minutes. Everyone can sort of talk in their groups and we'll just come back and have a little discussion on this. Okay, just in the interest of keeping this moving, we'll bring it back. So just out of curiosity, by show of hands, how many people think Juan was fired? Okay, a few. How many people think Juan quit? And a lot of people have no idea, it looks like. Yeah. No, so there's 2 different disqualifications. And one of the first things you have to do is kind of figure out what am I dealing with here? And often it's not clear, right? You know, in a lot of, sometimes it's very clear, here is your, notice, you are fired. Sometimes the I quit, but there's a lot in between. And to analyze problems, sometimes you got to figure out, okay, was the person fired or did they quit? And often the employer and the worker have very different accounts of what happened. So if we go from the perspective that Juan quit, what kinds of questions might you want to ask Juan? Yep. Yep. Always a good question. And so the suggestion there was to ask about hours worked, just to see before getting into the nitty gritty of, whether he qualifies for EI or is disqualified from EI. Do you have the hours to get in the front door? Yep. Yep. Yeah, exactly. So the suggestion there for the people online was to contact WorkSafe to inquire about the safety issues. So again, that goes to the issue of no reasonable alternative, right? So you're going to want to ask questions about what else did you do before deciding to quit, because that's going to be important. Yep.
I want to know
Yeah, great suggestion. So for the people online, that was, did he raise the concern in writing or through an email? And did he go above the supervisor to somebody else who might have the power to fix things? And again, great suggestions. These are all the right questions. Was there another reasonable alternative? Yep. Yeah, and so the suggestion there was the employer could be doing other things, and maybe this is largely set up to have Juan quit. Are there other factors, surrounding this? Because again, what's reasonable in the circumstances is going to depend on the severity of what's going on, right? Sometimes you might have to make certain inquiries and try to fix the problem other ways. Sometimes things are going to be so serious that really the only reasonable alternative is to quit. So yeah, investigating those surrounding circumstances. Yeah, great. Yeah.
One of the things I asked was whether possibly other coworkers, especially people who might have left the company, might be willing to come forward as witnesses, because there's seldom simply one incident around safety or, for example, the conduct.
Yep. And so for the people online, the suggestion was to talk to other workers, maybe workers who have left the company, who's willing to come forward to talk about what's going on. Absolutely. Because again, that maybe can show that it's just not reasonable to try to work with this employer. Like that's not a reasonable alternative because the decision's been made. It's just an unsafe workplace, right? And that could impact the context for sure. So, okay, so what if we come at this from the perspective that Juan was fired? Who thinks we have misconduct, or who wants to weigh in on this? Yep. Yeah, he hurled insults at the supervisor, and that could be construed as misconduct, perhaps. What could you maybe say to get around that? Does anybody think this wouldn't be misconduct, or? Yeah, they love trotting out the good old insubordination. The suggestion there was that he had abandoned his position, right? He was sort of beyond a refusal to work. He kind of went home, and they do insubordination, and they use that term, is often brought out as a form of misconduct. Yep. Yeah. Yeah. Right. So for the people online, that in case you can't hear it, that was the employer really started the thing by threatening to fire him, and the insults were kind of in response. And I think that could be part of the argument that this didn't rise to the level of misconduct, that this isn't really conduct that's inconsistent with the performance of job duties. It's a spat, between two workers, and doesn't really rise to misconduct. Yep.
I'm wondering if it's stronger, if on his record of employment, the employer said he was fired rather than he quit, because if he quit, he's got to prove the conditions, whereas if he's fired, the employer has to show, that it's appropriate.
Great point, and something I forgot to cover. So the point was around who has to prove what. If one quits, he has to, the commission and the employer have to show he quit, but then it's on to Juan to prove that he had just cause. If he's fired, it's on the employer, and by extension, the EI people, the commission, to positively show there was misconduct. It's not on Juan to disprove misconduct. It's on them to show misconduct. And, having the burden of proof is a thing, because you got to meet it. So yeah, it's a good point in terms of how you phrase things. Yep. Yep. Sonia, yep.
believe that sentiment one has to go back to work since not having a ladder, not all of your painting involves a ladder. So unless, I mean, there is the odd painter that truly up on a ladder.
Yeah.
But I think there's many comments of that employee should be remaining on the job and I'm willing to do other work, except unsafe work, and that protects them from being fired.
Sonia was just noting that here, Juan didn't just say, I'm not going to go up on the ladder and agree to do painting that might not be involved with the ladders in dispute. He left, which might not weigh in his favor, which I agree is a good point. Yep.
Okay. Well, I just think that it's not just the latter issue. It's an unsafe work environment because he's not allowed to speak and you know, being told to shut up when raising concerns isn't also part of an unsafe working environment. So I wouldn't work there, like even if I didn't have to go up on a ladder.
Yeah, absolutely. And I won't repeat that back because I think we have the mic. So I think the people on online can hear now.
Yeah, one thing it doesn't say is if there's a union involved here, because that would be another avenue for unsafe work is to go to the union as well.
Absolutely. Yeah. Yeah. Well, that's great stuff on that. We should probably move forward because I have a list of things I promised I would cover and 23 minutes to do it. So that was great. Thanks for all your contributions on that. That was awesome. Okay, I'm gonna start skipping things. Except for this, because now we are going to answer the questions. So when you apply for EI, the first thing you get is this thing called a benefit period. And that's the window with which you have to collect all your benefits. For regular benefits, it's 52 weeks. That's the window. You don't qualify for 52 weeks of benefits. You might qualify for 20 weeks of benefits. You might qualify for 35 weeks of benefits. They have to be collected within that window. And the windows are different for things like special benefits. Sometimes they're extended, sometimes they're bigger. So the answer to your question is people can crush all kinds of different kinds of benefits into a benefit period. If you have a benefit period, you may start out too sick to work. You may be well enough to work. You flip to regular benefits while you're looking for a job. And it's possible, for example, if there's a difficult pregnancy, the person might be off on sick leave, then on pregnancy benefits around the time of birth, and then on parental benefits, right? So you can definitely switch from one benefit to the next. So the challenge with the scenario you're talking about is that the benefit period would probably close, which means that the worker who was on pregnancy leave, who went back to work, would probably have to work enough hours, not because they're disqualified, but because their previous benefit window had closed. So they have to work enough to open up a new one, if that makes sense. There you go. It was only 20 minutes and about 20 slides, but I finally got to hopefully answering the question. Okay, I'm going to skip a lot of this stuff. I'm going to do, I'm skipping ahead because we've got, unless you see something you want me to talk about, and then you can say, stop, talk about that. But okay, so one thing I did want to talk about, because it is a bit of an emerging situation, is benefit entitlement. So what we've been talking about so far is getting through the front door. A lot of problems there, but not all the problems. Once you're through the front door, you still have to do the things you have to do to get benefits every week. You have to file cards or online reports every 2 weeks saying, I'm good. I'm looking for work. I'm available for work. Everything's okay. And if you're not, even though you qualified, you won't get benefits for those weeks. So the big one that is coming up now is availability. So the idea is that you have to be capable of and ready for work to get EI. And this creates, and here's the usual test to date. It usually requires you to show three things. One, a genuine intention to find suitable employment. You really want to get back to work. Two, you're expressing that desire through a job search. Always a good idea to have your clients document their job searches, or if they go check job boards or checking online, document everything. And the third, which is often the most difficult to understand, is not imposing personal barriers that unduly, that should say unduly. I wrote that slide back there about 20 minutes ago, that unduly limit chances of returning to work. All right. So if you lose your job and say, you know what, I'm only going back for $100 an hour. That's it. That's what I want. And I'm not going back without that. That may be a problem. If you're saying, you know what, I really want to go back to work. I'm going to do a job search, but I'm off to take a vacation somewhere for a little bit. That's a problem. But increasingly, we are seeing some difficult cases where the conditions are not so much barriers that the individual has imposed. For a variety of reasons, people just are limited to part-time work, right? So the most classic example, tying into the question you were asking about the PWD benefits, a lot of our clients can work. A lot of our clients can work. They can't work full-time, right? They may not be able to work full-time, and they may be limited in terms of the sort of the circle of jobs. But EI is in this mindset of availability means 9 to 5, Monday to Friday. So we're starting to see this really play out. Another area where this is really starting to play out for those of you who work with temporary foreign workers or foreign workers of any kind is work permits, right? I'm not an immigration law expert, but I think closed work permits are still a thing that exists. And if you lose that job, you actually can't go get another job because your permit doesn't let you, right? So is that a personal barrier? Are you, you want to work, you want nothing more than to go work. And in fact, you wish this permit didn't have this stupid restriction, but it's there. So are you available? So these kinds of issues are really starting to come up. And then, yep. Yeah. All the time. Yep. And generally a lack of childcare will render you unavailable. Yeah, generally. You can work around that by showing like, you know, I've got mom, you know, who can take the kids if needed. I've got a neighbor who's helping. You can try to patch things together, but generally a lack of childcare renders people unavailable, and it's harsh.
We actually had, we stated that the only hour we could find childcare was
Yeah. Brutal. Yeah. Silliness. Yeah. Real harsh. Yep. So,
Yeah, we have similar situations, not so much with the childcare as been previously mentioned, but with clients who are homeless, and so they'll be talking to an officer, information officer on the EI line, and they reveal that they're, you know, have nowhere to stay, and they're not able to find clean clothes, or, you know, like take a shower, like look presentable, like for work, and then they get cut off because they're seen as being unavailable for work.
brutal.
Even though like it's circumstances beyond their control. So
Yeah.
like any tips you have around overcoming, because, you know, I mean, it is a barrier, but it's not, personal barrier implies that you're deliberately doing something, like you have a choice and you're deliberately choosing to hinder your own ability to be available.
Yep. A lot of this nonsense stems from a federal court of appeal case. You know, I'll try to roll back my personal remarks on this one, but it was a claimant, house burned down, fire burnt to the ground, didn't have clothes, didn't have boots. And they're like, well, sorry, you're not available for work. So good day to you. And that has kind of spiraled into this, this nightmare. The only tip I can give is that for all of you in advocacy agencies, and especially those who have a legal advocacy component, but also other services through your agency, availability is correctable, right? So you as legal advocates can fight that decision that the client wasn't available, but you can also try to help the client by creating the conditions that are going to overcome those barriers. Easier said than done, right? So I would just, the only tip I would have would be to find it from both ends. One is looking back, were you available for these weeks? But the other is, how can we get you set up with services that are going to allow you to be more available for work, for lack of a better term, going forward? Yeah. And I have fought some cases. I'm still waiting for some decisions, so I can't share them. Or they got decided on other grounds that it says setting a personal condition. And to me, that doesn't include conditions you didn't set. Like what they're talking about here is we need people to be doing their best to get back to work. That's what this is all about. This isn't about punishing people for pre-existing conditions outside their control. I've had some success, some people, some decision makers agree with that, others don't. So that would be the other argument I would make, is to say they're just not personal conditions the individual has set. And sorry, was there another question or? Yeah.
On your previous slide, you use the term suitable employment. Is there a definition to that term?
Yeah, there is. Section 9.000. There's a bunch of, look around section 9 of the regulations, not the act, the EI regulations. So it has to be within their physical abilities. There's something about commuting distance. And it has to not, I believe it has to not conflict with any firmly held belief system of the worker. So yeah, look around in the regulations. Yeah.
Maybe a further question of this is, like, if someone, say, lost their job in a specialized area or a trade, but Service Canada is saying McDonald's is hiring in your area, like, will someone disqualify themselves if they continue to look for specialized work?
Great question. Here's how it works. At the front end of an EI claim, you're allowed to be more picky. At the back end of an EI claim, as you remain unemployed, you must be less picky. I don't think it would ever be fair to say that a worker with highly specialized skills would have to work in a fast food restaurant or in something completely foreign, like just a completely new industry. But what they would say is, okay, on week 1, you're a worker with specialized skills. You can look for essentially that same job. And that's okay. Okay, now we fast forward 8 weeks. Well, you didn't find something in that. So now you got to expand. You got to start looking a little further afield. Fast forward 8-10 weeks, you got to look farther afield from that. So the short answer is, for lack of a technical legal term, your pickiness must go down the longer you're on claim. That makes sense. And sorry, was there another question? Okay, so this ties into, and I'm finally getting to the stuff people wanted to hear about. Okay, so the interaction with, this doesn't quite get to what you were asking about, but this transition from all these other schemes. So here's the problem. People got terrible advice, like all through this. Sometimes it was just sloppiness. Sometimes it's because they were, again, rolling out schemes, had no idea what was going on. Workers weren't trained when giving advice. People got terrible advice. So we're starting to see this issue where EI was essentially telling people you're okay to get EI, and the person wasn't. And EI is now claiming that normally you send in your cards and they assess your availability for work right on the spot. Well, EI is claiming that these pandemic rules essentially let them sit back and then roll out of bed 6 or 8 months later and say, actually, we're going to go back. Oh, sorry. We're actually going to go back and look at your availability 6 months ago and ask for all the benefits back. Whereas if they had looked at the information provided at the time it was given, they would have said, whoa, you're not eligible for EI, and there wouldn't be this massive debt. So this is a thing, and these should be fought. There's a general idea that there are some parts of the act where qualification is qualification. You cannot qualify with 419 hours if the act says you need 420. You just can't do it. But then there are decisions like availability where it could go this way or it could go that way. On those, it could go this way or it could go that way decisions. They have a policy that they're not supposed to go back and re-adjudicate those based on the same facts. If you lied or weren't forthcoming, like if you didn't tell them you were in school and they find out you're in school, well, that's different. But if you're fully honest, the idea is this protects you. The principle is if I'm honest and I give the information, I'm protected from just having them take a second look at the decision. EI is claiming that is all out the window and that they have magically been given this power to sit back and just, even though, and this is mostly for students, where students are saying, yeah, I'm in a full-time course of study. And someone on EI says, oh yeah, you can get benefits, that's fine. They collect 6-8 months of benefits. Then someone looks at it 8 months later and says, oh, actually, no, I want all that back. Whereas if they had just looked at the information at the time. So these should be fought on the basis that, number one, they shouldn't be allowed to do this. And even if they can, it's an option to go reconsider a claim. They don't have to. So it's a perverse exercise of discretion to like take someone who is totally honest, sit on it for 8 months and then go back and demand the benefits back. It's one thing to cut the person off going forward. Okay. But to demand all the money back is really, really harsh. So that's one issue I did want to flag. And then another issue that we talked about briefly was part-time availability. And I think before there was a pretty strong notion it had to be full-time Monday to Friday. That's what was required. There's been a few decisions now that have said, no, it's a little more nuanced than that. That being available is a contextual analysis based on the individual circumstances. And in particular, what makes sense in anything insurance law is what we're insuring should kind of match what you lost. So if you qualified for EI doing part-time work, there's some emerging cases that sort of say, well, if you qualify using part-time work, you shouldn't be required to go find full-time work because we're not insuring full-time work. We're insuring your part-time work, right? So that there's an idea that the work that you have to look for should roughly match the work that you did before. And this comes out of what you were asking about a skilled worker, right? Like we don't ask workers to just go off and do something completely different than what they were doing before, at least not right away. So again, if you see these disqualifications based on, well, you're only available for part-time work and the worker qualified with part-time work, you should fight them. Because I think there's an increasing appetite and an increasing ability to fight these. I was going to do a fact pattern. I've been talking a lot. I'm going to skip it because, again, I promised to get to some things around overpayments. But I guess just out of this fact pattern, I'll just flag. One thing we are seeing a ton of now is international student problems. So it appears that if you're an international student, generally you get a work permit that lets you work 20 hours a week. So sometimes that combined with your schooling pretty much renders you unavailable. But sometimes it's a little more flexible. The program is self-directed. It can be done on, and 20 hours is pretty much right. It's like the litmus test for this issue because 20 hours of availability is right smack down the middle of full-time and not being available. So I raised this one just because we had an interesting case on this that was kind of right on the line. And the worker was actually successful. And again, based on this fact pattern, just because we don't have time, the worker was successful because the worker qualified for EI on this exact same permit. So what the commission was essentially saying was, you were available on this work permit to get enough hours to qualify for EI, but then poof, magic, after you lose that job, you're suddenly unavailable for work, even though that you worked on this exact same permit to qualify, nothing's changed. So again, it's kind of this, what came before should match what comes after idea. That's sort of starting to emerge. It's not that concrete yet, but okay, I'm going to skip special benefits and what they qualify for. And I added some slides because I knew someone was going to ask me about sort of these old legacy debts. So yeah, there's a lot of people who got bad advice, collected the wrong benefit, and they're now being asked to repay it. So I'm going to start with EI and then I'll talk about some of the other ones. So EI does have a concrete mechanism to, quote, write off a debt. Now, write-off is a weird legal term. It actually doesn't mean the debt disappears. It means they scratch it off their accounting books. But for all intents and purposes, it means they're not going to collect it. EI is a formal mechanism to do that. So importantly, you should still fight the debt in the first place. You only get here if there's actually a legally owing debt. Fight the debt. That's better. Get it struck away. But if you can't, you can apply to write it off. The problem is that the CERB and the CRB, the Canada Recovery Benefit, had no provision for write-off. And we have poured over the Financial Administration Act. I don't recommend anyone do that. It's very boring. Looking for any kind of way to try to get at writing these off, and we can't find one. So where that leaves us is that for EI, you have a formal mechanism in section 56. Good luck trying to find someone who's actually going to give you the information you need. But there is that legal section that says we can write off a debt that's owing. And you can do it on a bunch of different reasons. Undue hardship is one of them. That's the big one for a lot of our clients. But there are others that are less common, like if it's a death, bankruptcy. It's always discretionary. You don't have a right to it, but the commission can do it. There's a couple of others, commission delay or error or a mistake by the employer on the ROE. The problem is that these ones require that it not be caught within a year. So essentially the commission has given themselves a year to catch the problem and then say no write-off for you because we got it within a year. So there's some problems there. And overlying all of this is that it can't be based on false or misleading information from the claimant. This is the best I can do for you, and I can circulate this after for how to try to access the write-off process for EI if someone's been wrongly paid EI. It's almost impossible. The CRA acts as like the debt collector for all federal agencies. So what happens is the EI commission says, go talk to CRA, and CRA says, we're just the de facto collection agent, go talk to the commission. And you go around in circles until you've lost you've lost your mind. But that's the best I can come up with. For the other federal benefits, Sonia, to answer your questions, I don't have a good answer for you on how to write these things off. The one exception is the government passed, there was this whole thing where whether you qualified for CERB with $5,000 gross or $5,000 net, and they passed a regulation to write off for the people who got caught up in that mix up, but that's not a lot of people and it's not a lot of the clients we deal with. So it's not that helpful. So the best you can do often is to create a payment plan, and that payment plan may be not paying or a couple of dollars or something, but at least it will provide some measure of comfort, although I gather they can still scoop some other benefits. And so you asked about qualifying. The fact you have a debt from a previous one of these other programs should have no impact whatsoever on your ability to qualify. The question is, are they going to scoop the benefits, right? You know, to offset a debt. And yes, they can do that. Whether they will or not, I don't know. It has no impact on qualification. The one exception to that would be if on a previous EI claim, someone has knowingly given false or misleading information, they can impose what's called a violation. And if you get a violation on your file, it increases the number of hours you need for the next claim, for the next 5 years or so many claims. So if someone is being asked to repay monies because they have essentially lied before on an EI claim, then yeah, it can bump up the violation. But CERB and the CRB, you can't impose a violation for false information on a CERB claim or a CRB claim that would transfer over to a future EI claim. Does that make any sense, or yeah? Okay. Sorry, I tried to do that as quick as I could. I see we're at 10 and that's the end. Look at that. So thank you very much, folks. And sorry if I didn't get to everything, but EI at an hour. Yep.
It's on Sked now. So for online participants and in-person participants, Kevin's slides are on Sked.
There you go. And I have to apologize. I took a bunch of, I figured I would get questions on things. So I started pulling slides from other decks just to make sure they were there. So if it looks completely incoherent, that's why. So if the word questions appears right in the middle, That's because I added on at the end because I knew Sonia would ask tough questions. Right. Okay. Thanks so much, everyone.
Thank you.